The morning Marcus Webb walked into the Fulton County Courthouse, nobody looked at him twice. He was 15 years old, wearing a dark blazer that was slightly too big for his shoulders, carrying a manila folder pressed tight against his chest. The folder was thick, stuffed with handwritten notes, printed statutes, and photocopied pages from legal books he had borrowed from the public library over the past 6 months. He had read every single page at least twice. The courthouse smelled like old paper and floor polish. People moved through it quickly, with the kind of focused energy that comes from knowing exactly where they are going. Lawyers in sharp suits rolled suitcases with wheels. Clerks carried stacks of documents. A security officer stood near the entrance, arms crossed, watching the door. When Marcus stepped through the metal detector, the officer looked him up and down and asked who he was there with. "I'm representing myself," Marcus said. The officer paused for a moment, then pointed toward the elevator without another word. Marcus took the elevator to the 3rd floor and found courtroom 7. He pushed the door open quietly and walked inside. The room was wide and tall, with high ceilings and rows of wooden benches along the back. The American flag stood on one side of the judge's bench. A Georgia state flag on the other. The room was not yet full, but a few people sat in the gallery, most of them waiting for other cases. Marcus sat down at the plaintiff's table on the left side. He placed his folder on the surface, opened it, and began reading through his notes one more time. His handwriting was small and neat. He had underlined certain phrases in red pen and added small stars beside the points he did not want to forget. At the defendant's table across the room, a man named Leonard Holt arrived 8 minutes later. He was tall, well-dressed, with silver hair combed back and a briefcase made from dark brown leather. He had been practicing law for 22 years. He had handled hundreds of civil cases, landlord disputes, property claims, lease violations. He was the kind of attorney that landlords called when they wanted to be sure of the outcome. Holt set his briefcase on the table, clicked it open, and began arranging his papers. His paralegal sat beside him, a young woman with a laptop, fingers already hovering over the keyboard. Holt glanced across the room at the plaintiff's table. He saw the boy in the oversized blazer. He saw the manila folder. He did not say anything. He simply looked away, turned to his paralegal, and said quietly that they would probably be done before noon. In the gallery, Dorothy Webb sat in the 2nd row. She was 63 years old, with reading glasses resting on top of her head and a small Bible in her lap. She had raised Marcus since he was 4 years old, after his parents left and never came back. She had worked as a school cook for 30 years. She had never been to court before in her life. She sat with her hands folded, watching her grandson arrange his papers, and she did not say a word. The case had started 5 months earlier. The landlord, a man named Gerald Crane, had sent Dorothy a notice saying she had 30 days to leave the apartment where she had lived for 11 years. He claimed she had violated the terms of her lease by having a dog on the property. Dorothy did not own a dog. She had never owned a dog. She had asked her neighbor, once, to watch a small dog for a weekend while the neighbor was out of town. Someone had apparently seen it and reported it. That was the entire basis of the eviction. No attorney would take the case on contingency because the financial amount involved was small. The legal aid offices in the city were full and had a long waiting list. Dorothy had almost accepted the situation. She had started looking at other places to live. Then Marcus sat her down at the kitchen table one evening and told her he had been reading. He had been visiting the public library every day after school for 4 months. He had read the Georgia Landlord-Tenant Act from beginning to end. He had read case summaries from the Georgia Court of Appeals. He had looked up every legal term he did not understand and written the definitions in a small notebook. He had found 2 cases from Georgia courts that were almost identical to their situation, cases where judges had ruled in favor of tenants because the landlord had not followed the proper process. And he had discovered one very important detail: Georgia law required that a landlord give 60 days written notice before beginning eviction proceedings for a lease violation. Gerald Crane had given 30. Dorothy had listened to everything Marcus said. When he finished, she was quiet for a long time. Then she said, "All right. We go to court." Judge Patricia Okafor entered courtroom 7 at exactly 9 o'clock. She was a woman in her late 50s, with a steady walk and an expression that was neither warm nor cold, just precise. She had been a judge for 14 years. She had seen every kind of person in her courtroom. She sat down, adjusted her glasses, and picked up the docket. She read through the case summary. She noted the plaintiff's name. She noted that the plaintiff's representative was listed as Marcus D. Webb, pro se. Pro se was the legal term for someone who represented themselves without an attorney. She looked up from the papers, looked at the boy sitting at the plaintiff's table, and asked him directly, "Young man, do you understand what it means to represent yourself in this proceeding?" Marcus stood up. "Yes, Your Honor. It means I will present the case on behalf of the plaintiff, Dorothy Webb, who is my legal guardian and has given me written authorization to speak for her today." He placed a signed letter on the edge of the table where the clerk could collect it. Judge Okafor looked at him for a moment. "Proceed," she said. Leonard Holt gave his opening statement first. It was smooth and practiced. He explained that his client, Gerald Crane, had followed all proper procedures. He said the lease agreement was clear about pets. He said the tenant had been warned. He presented a photograph of the dog taken by a neighbor. He was calm, confident, and finished in exactly 4 minutes. Then Marcus stood up. He did not use any notes for the opening. He had memorized it. He spoke slowly and clearly, choosing each word with care. He told the court that the photograph showed a dog that did not belong to his grandmother, a fact that the neighbor who took the photograph could confirm. He told the court that the lease agreement defined a pet as an animal permanently kept on the property, and that watching a neighbor's animal for 2 days did not meet that definition. He told the court that Georgia Code Section 44-7-50 required 60 days written notice before an eviction for a lease violation could begin. He stated the date the notice was sent. He stated the date the eviction proceedings were filed. The difference was 31 days. He sat down. The gallery was quiet. Holt's paralegal, who had been typing steadily, stopped. Judge Okafor, who had been making small notes, set her pen down for a moment and looked at Marcus. Then she picked her pen back up. Holt adjusted in his seat. He had expected this to be easy. Now he understood it was not going to be easy. He shifted strategy. When Marcus attempted to submit the text message records between Dorothy and her neighbor, messages that showed clearly when the dog arrived and when it left, Holt objected. He argued the messages had not been properly authenticated. He cited the rules of evidence. Marcus had read about this. He had found it in a section of a Georgia appellate court decision from 2009, which discussed how text messages could be authenticated by the person who sent or received them, through testimony. He told the court he intended to call Dorothy Webb to the stand briefly to authenticate the records. Judge Okafor allowed it. Dorothy sat in the witness chair, smoothed her dress, and answered 3 questions in a clear, steady voice. The messages were admitted. Holt pushed harder. He raised a procedural objection about the format of Marcus's written submissions. The objection was technical and designed to confuse. Marcus paused. For the first time since the hearing began, he was quiet for a few seconds longer than he had been before. He looked down at his folder. He found the page he needed. He cited the correct rule of civil procedure and explained, briefly and politely, why the objection did not apply. Judge Okafor overruled Holt's objection. Holt sat back. He was no longer thinking about lunch. The moment that people in that courtroom would talk about for a long time came during the cross-examination of Gerald Crane. Crane was a heavy-set man in his 60s who sat in the witness chair as though he was used to being believed without question. He had been a landlord for 20 years. He had been in court before. He did not appear to be worried about the teenager across the room. Marcus stood up and walked to the center of the room, a few feet from the witness stand. He had a single page in his hand. He asked Crane to confirm the date that the notice of eviction was delivered to Dorothy Webb. Crane confirmed it. He asked Crane to confirm the date that the eviction filing was submitted to the court. Crane confirmed it. He asked Crane how many days were between those 2 dates. Crane said he believed it was 60 days. Marcus held up the single page, a copy of the court filing with the official date stamp. He asked the clerk to enter it into evidence. The clerk did. Marcus walked slowly back to his position in the center of the room. He asked Crane to look at the filing date on that document and tell the court what it said. There was a pause. Crane looked at the paper. Something changed in his face. He said a date. It was 31 days after the notice. Not 60. Marcus asked Crane, gently, without raising his voice, whether 31 days was the same as 60 days. Holt objected. Judge Okafor overruled him. Crane said no, they were not the same. Marcus thanked the witness and returned to his seat. The courtroom was completely still. Dorothy Webb, in the second row of the gallery, had both hands pressed flat against her Bible. She was not crying yet, but she was close. Judge Okafor called a brief recess. When she returned, she did not take long. She reviewed the documents. She looked at the dates. She looked at the statute. The law was clear. The notice period had not been met. The eviction proceeding had been filed prematurely. The case against Dorothy Webb could not stand. She ruled in favor of the plaintiff. She ordered Gerald Crane to reinstate the lease on its original terms. She ordered the return of Dorothy's security deposit in full. She ordered Crane to pay the court filing fees. Then she did something that the court clerk, who had worked in courtroom 7 for 9 years, said she had never seen the judge do before. Judge Okafor looked directly at Marcus Webb and spoke to him on the record. She said that in 14 years on the bench, she had presided over hundreds of hearings involving self-represented parties, and that the quality of preparation and the composure she had witnessed from him that morning was something she would not soon forget. She said she did not know what his plans were for the future, but that the court would be fortunate to see him again someday, on either side of the room. She adjourned the session. The gavel came down. For a moment, nobody moved. Then Dorothy Webb stood up from the gallery bench, walked through the small wooden gate, crossed the room, and put both arms around her grandson. She did not say anything. She did not need to. Marcus stood very still inside her arms, and for the first time since he had walked through the courthouse door that morning, he let himself breathe. Holt packed his briefcase in silence. He did not speak to his paralegal. He did not look across the room. He walked out the way he came in, except this time there was no confidence in his step. Just quiet. Outside in the hallway, a journalist named Carol Sims was waiting. She had been covering a different case on the same floor that morning when the court clerk, on a break, mentioned to a colleague that something unusual was happening in courtroom 7. Carol had slipped in at the back during the cross-examination and had stood there, notebook in her hand, barely writing, just watching. She approached Marcus in the hallway and asked if she could speak with him. Marcus looked at Dorothy, who nodded. Carol asked him several questions. How long had he been preparing? What made him decide to fight the case? Where had he learned the law? He answered each question quietly. When she asked about the cross-examination, about how he had constructed those questions in that particular order, he thought for a moment before answering. I learned from watching, he said. Every question needed the one before it to mean anything. If you change the order, the answer changes. I wrote the questions out about 30 times before I got the order right. Carol wrote that down word for word. The article ran 4 days later. It was not a long article, but it was specific and honest, and it described exactly what had happened in that courtroom with enough detail that readers could picture it. It was shared widely. A professor of law at a university in Atlanta read it on a Sunday morning and sent an email to the journalist asking if she could pass his contact information to Marcus. Marcus received the professor's message on a Wednesday evening. He read it twice, then set his phone down on the kitchen table. Dorothy was in the next room, watching the evening news. He could hear the sound of it through the wall. He picked up his library notebook, the one where he had written all the legal definitions, and opened it to the last written page. Below his most recent notes, he wrote the professor's name and the date of the email. Then he turned to a fresh page. He did not know yet exactly where things were going. He was 15 years old. He had a science test on Friday. He still had to do the dishes. But something had shifted, not just in the case, not just in the apartment where Dorothy could now stay, but in Marcus himself. Something had settled and solidified, the way a decision feels when you stop questioning it and simply know. He had walked into that courtroom carrying a folder full of other people's words, statutes and rulings and definitions written by lawyers and judges long before he was born. But in that room, for those few hours, those words had become his. He had used them to protect the person who had protected him his entire life. He closed the notebook. He got up, went to the kitchen sink, and started doing the dishes.